Hello everyone and welcome back to lecture. We are on our second to last lecture for the semester and we are in our last unit overall. As I mentioned earlier, I broke this chapter up into 2 lectures just so you wouldn't have to sit through one big giant lecture. Plus there is enough in this chapter that we could really talk about this topic for a couple of days. In the first part of the lecture, we're going to be focusing more on the legality surrounding the death penalty and some of the constitutional issues that are surrounding it. In part 2, we're going to be focusing more on what happens when executions go wrong and when an execution is botched. We're also going to be talking about wrongful convictions and the efforts that are currently ongoing to exonerate those individuals who are sitting on death row. Let's go ahead and get started by looking at the use of the death penalty in the United States overall. So when we're talking about capital punishment, we're talking about the execution of an offender who has killed another individual. Typically, states are going to require the conviction of either first degree or capital murder or felony murder in order for an individual to receive the death penalty. It just depends on where you're at. At the federal level, the same holds true, but you can also receive the death penalty for acts of terrorism, treason, espionage, etc. Now, you'll note that most often you have to kill someone in order to receive the death penalty today. Historically, we used to execute a lot more frequently than some of the executions that take place currently. You could receive the death penalty for a variety of things, including murder, but certainly not limited to just that. We are the only industrialized nation to still use the death penalty. But the question we now ask is, what is really an industrial country? In what company are we sort of lacking? Normally, when we talk about industrialized countries, we mean those that make up the G8. So the United States, Italy, the United Kingdom, Germany, France, Japan, Canada, Russia, and the European Union. You might be surprised that I said Russia, but capital punishment in Russia has been indefinitely suspended. Although it does remain active and codified in its law, it's just not currently being used. There exists both an implicit moratorium that was established by President Yeltsin in 1996 and an explicit one that was established by the Constitutional Court of Russia in 1999. And most recently it was reaffirmed in 2009. Russia has not executed anyone since 1996, and the regulations of the Council of Europe prohibit it from doing so at any time in the future. As we already discussed this semester, the death penalty has gone through a series of ebbs and flows in terms of popularity and its use in this country. For a short while, the death penalty was deemed unconstitutional by SCOTUS in 1972. In the case of Furman v. Georgia in 1972, this was really a joint case that was brought up by several inmates in Georgia, Texas, and other states. In this case, the inmates argued that the use of the death penalty was all over the place. Courts were sentencing defendants to the death penalty for anything and everything. The victims died in some cases, but survived in other cases. There was really no uniform application of the punishment, and SCOTUS ruled that the use of the death penalty really is violating the 8th Amendment, cruel and unusual punishment. And the federal government essentially put a de facto moratorium on capital punishment. The death penalty was not only being used for homicide cases, but instead it was being applied to rapists, to juveniles, the mentally ill, and a very large proportion of African Americans were being executed and sentenced to death row comparative to whites, despite somewhat similar numbers of crimes being committed by both groups. The court ruled that there was an arbitrary application occurring. Therefore, it was resulting in the de facto moratorium on the death penalty that I mentioned earlier, and it essentially commuted everyone who was currently on death row to life in prison without the possibility of parole. As you can imagine, states that wanted to continue using the death penalty were upset by this ruling and started scrambling to reform their death penalty regulations so that they could continue the practice. States were still wanting to use the death penalty, but SCOTUS basically said that until you fix this system, you cannot use it. You need to include some safeguards that protect individuals who are subjected to the death penalty. So during the moratorium on capital punishment, states started drafting new laws and protocols that would implement the things that SCOTUS wanted in Furman. The SCOTUS then reviewed these safeguards and said, all right, you can reinstate the death penalty. 4 years later, SCOTUS ruled in CRIJ v. Georgia, 1976, that states could start using the death penalty again. However, there were still more safeguards to come. In 2005, SCOTUS finally addressed the issue of the execution of juvenile offenders. In Roper v. Simmons 2005, the court heard the case involving Mr. Simmons, who was only 17 years old when he and two other friends conspired to murder a woman. Essentially, they planned to break into her house, murder her, tie her up, and toss her off a bridge. Only two of them actually went through with the plan. Mr. Simmons confessed to the murder and had several mitigating factors in his favor involved in this case. One was his age, he did not have a prior record, etc. The jury still felt as though his engagement in this crime was worthy of the death penalty, even though Simmons testified that it was an impulsive plan and that he was not a hardened criminal. Before Roper v. Simmons, the minimum age was 16 years of age for execution, but prior to the standard of 16 years of age, kids were being executed historically as young as 11 and 12. The standard for 16 years old was set in 1988 by Thompson v. Oklahoma. Now, with the reversal of Simmons' sentence, the court essentially established a new standard for execution, stating that you have to be 18 years of age or older at the time of the murder. This means that no minor, under any circumstances, can be sentenced to death. The last safeguard I want to address focuses on the actual fate of the victim. Two cases here, Coker v. Georgia and Kennedy v. Louisiana, are both cases in which it involved the rape but not the murder of the victims. In the Coker case, we had an adult victim, and in the Kennedy case, we had a child victim. In both cases, SCOTUS stated that even though the crimes were very severe in nature and particularly heinous, they did not necessarily warrant the death penalty because the victim did not die in either case. So now SCOTUS has established a second standard that states in order to receive the death penalty from the state, your victim must die. So parts of the country are using the death penalty. It's not mandatory for states to use the death penalty, and in fact, quite a few states choose not to use it. However, those that do use the death penalty, of those ones, about more than 60% of those sitting on death row come from 5 states: California, Florida, Texas, Pennsylvania, and Alabama. But Texas is the big daddy of them all, and we're going to talk about them in just a second. Even though California does have a very good-sized death row, they're not very eager to execute. They've only executed 13 individuals since the reinstitution of the death penalty. The last one they executed was in 2006. California's death row has currently more than 850 individuals sitting on it. At the time of this recording, there were 2,943 inmates on death row. In the year before, 27 executions took place, 13 of them here in Texas. Hands down, Texas routinely executes the largest amount of inmates every year and has the largest execution count since the reinstatement of the death penalty post-CRIJ. So 28 people were executed and an additional 49 were added to death row. The 3 botched executions were in Oklahoma, Arizona, and Ohio. And we're going to talk about the Oklahoma one later in the lecture, since it is the one that has the most attention paid to it. The 6 exonerations increased the total count of exonerations to 156 off death row since 1973, and it seems as though that number just keeps increasing and getting bigger and bigger. Because the death penalty is primarily used for first-degree capital or felony murder, we see that the majority of death row inmates are sentenced at the state level. However, as we said, the federal government does have the death penalty as well. Federal death row looks a little bit different than some of the state death rows. Not only are the crimes a bit different, but it's highly unlikely that you will ever be executed by the federal government. In fact, only 3 people have been executed since 1976. The newest member to federal death row is Dzhokhar Tsarnaev, who you might know as the Boston Marathon bomber. Tsarnaev was prosecuted federally rather than at the state level due to the nature of the offense, but he was not tried by the military, something that many other federal death row inmates have experienced. So that currently makes him the only individual to be on death row for terrorist-related offenses who was never tried by a military court, since he was tried by a civilian one. All right, So we have talked about some of the safeguards that are surrounding the use of the death penalty and how often the death penalty is used in the U.S. But let's talk for a moment about how to get on death row and the procedure surrounding its use. First of all, when SCOTUS ruled in the CRIJ case, they stated that certain procedures must be put in place to make sure that the death penalty is being applied evenly and only in cases where the offense was bad enough to warrant its use. So that means that the death penalty cannot be applied in all homicide cases, but certain things need to occur in order for the homicide to be elevated to capital or first-degree murder. One of the biggest issues that prosecutors have to prove is that there were more aggravating circumstances present than there were mitigating ones. Remember, aggravating circumstances are things that increase the severity of the offense, where mitigating circumstances decrease the severity of the offense. When we're talking about aggravating factors, we want to look at who the victim was. Was it a minor or an elderly person? Was it a police officer? Was it an elected official? Was there more than one victim? Are we talking about a serial offender who has multiple kills? Did the offender commit a hate crime against a racial or a social minority? Those are all considered aggravating factors for a case. In comparison, mitigating factors are things that decrease the severity of the offense or allow for some negotiating room for the offender. For example, is the offender a minor? Well, based on what we already learned in lecture, we know that it is unconstitutional for a minor to be executed, so the death penalty is going to be off the table for that individual. Does the offender have a low IQ or some other mental deficiency that would make him or her ineligible for the death penalty? Was the offender the victim of abuse? Think of it this way. For years, maybe my spouse beat me and abused me physically and sexually. One night I snap and I murder my significant other. That history of abuse might be enough to serve as a mitigating factor for the offender in question. So once the prosecutor has decided to go after the death penalty and has secured a first-degree or capital murder conviction, now the sentencing phase must occur. One of the biggest changes in terms of sentencing is the delay in sentencing and the use of a death-qualified jury. When we talk about this delay, we're really meaning the use of a bifurcated trial. This is really nothing new. A lot of courts operated this way. And a bifurcated trial simply means that your conviction and your sentencing are going to take place at different times. This might be a matter of hours or a few days or even a few weeks. It just really depends on the state and the jurisdiction you're in and how busy they are and how full the docket is. The rationale for this method is to allow the jury time to breathe, to take a moment and think about the ramifications about what is going to happen. The old system would allow for the verdict and the sentence to be read simultaneously, and there was often a rush to judgment, aiding to the arbitrary and capricious application of the death penalty in the past. But when it comes to the sentencing, courts are now required to sit a death-qualified jury to hear the case. This means that the jurors are not opposed to sentencing the individual to the death penalty, but that they believe that it should not be an automatic sentence either. They have to be open to not suggesting the death penalty if the circumstances better suit life in prison. In order to receive the death penalty, there has to be a unanimous vote from the jury. So, if you have someone on the jury who does not believe or support the use of the death penalty, you're going to have a rough go from the start and you're never going to get that unanimous vote that you're needing. Appeals are one of the reasons why the death penalty and time on death row is getting longer and longer. This is the one punishment you can't take back. There is no release from prison and no recompense from the state once they execute you. So they have to make sure that there were no procedural errors anywhere. And we know from the increasing amount of exonerations that these errors happen more often than we would like to admit or to recognize. It is important to get this right, guys. You hear the arguments from some individuals who say the cost associated with the death penalty would go down substantially if we just eliminated the appeals process and we executed these inmates quicker. But the problem is that we know we have executed innocent people in the past. We know it, and it has been confirmed on multiple occasions. How can we continue to speed up the process if there is any possibility that more individuals are out there and we just don't care enough to confirm their guilt 100%? So now it's time to talk about the actual methods of execution that are available to us. It's no shock to any of us that we have been executing offenders for a long time in this country. Even before we were officially a country, we've been executing offenders. But the issue is, if we're going to try to continue to execute offenders and we just maintain the status quo, how are we ever going to evolve to make the process better overall? There's nothing fun about killing another person. This process takes a toll on the individuals who have to carry out the execution. And that's something that we really don't think too much about. We like to picture our executioners in a black hood, and it's a person who almost enjoys doing their job. Otherwise, how can they possibly stomach killing offenders for the state? I've actually posted a really interesting video clip on Blackboard for you all that's part of a documentary called 14 Days in May. And this video clip focuses on the role, really focuses more on the role of the executioner rather than the inmate, but you get a little bit of both. But it takes a look at how the prison goes through the process of preparing for an execution. It's a part we don't necessarily think about or see too often. But the more medical and the more clinical the execution, the less chance there is supposed to be for a botched execution. We're going to talk more about those in part 2 of the lecture, but there's always a chance that the execution will go wrong, and in some cases it has. Traditionally, executioners would hang the offenders, but there were always cases in which the noose didn't set properly and the neck didn't break. There is a certain way you have to place the noose so that the individual just simply doesn't suffocate to death, and that's happened before too. If there is a better way to do something, and there always is, we evolve, the court suggests that that's the way to go about things. In 1958, SCOTUS ruled in Trope v. Dulles, a case that wasn't even initially about the death penalty, that as a country, the United States must continually adapt and change to what is new and current and relevant. If there is a better alternative out there and it will cut down on the amount of time that is needed to execute someone, or if it will cut down the amount of pain that the inmate feels, then we need to be using those types of methods. SCOTUS basically ruled that this is considered part of the evolving standards of decency in this country. So basically you can still use the death penalty, that's what the court's saying, but you can't make the death extraordinarily painful for the inmate, and you can't make the death linger. Kill the inmate and be done with it. That's the purpose of the death penalty. The state's role is to not torture or to extract revenge. It's simply to carry out the punishment. So we've listened to the court and we have evolved. Hanging turned into the electric chair, which turned into lethal gas in some places, and then turned into lethal injection almost completely across the board. 31 states and the feds use lethal injection, but some states have alternatives as a secondary form of execution. Some states will still use electrocution, but it's been quite a while since anyone has actually executed an inmate that way. They still have it mainly because of the timeline of sentencing. If an inmate was sentenced before a certain date, they still may be eligible to be executed in the electric chair. Other states have alternatives in case they can't get access to lethal injection cocktails. For example, in April 2015, the Oklahoma legislature unanimously approved a bill that would bring the gas chamber really, back to Oklahoma after the extremely botched execution of an inmate who was executed via lethal injection. And we're going to talk about that one later. The state legislature approved the measure because it anticipated some sort of pressure from outsiders to review the protocol that was used for lethal injection, which is exactly what happened. That pressure did show up. However, the current use of lethal gas is going to be done differently than it has happened in the past. Currently, they're going to be using nitrogen gas, which results in nitrogen hypoxia. You breathe in the nitrogen gas, and the oxygen in your bloodstream is replaced with nitrogen, which ultimately is going to suffocate you, causing your death. Alternatively, Utah has reinstated the firing squad in 2014. They previously had it up till 2004, and then they brought it back at the end of 2014 in the wake of the botched execution that I mentioned previously that took place in Oklahoma. They thought there were going to be issues with the continued use of lethal injection should a case make it all the way to SCOTUS. This is a slide that shows a map of the United States and the different uses of the death penalty throughout the country. The white and light blue states are those who have abolished the death penalty or have abolished the death penalty but have not done so retroactively. The darkest orange states they show the use of lethal injection with some alternative given specific circumstances. The middle orange color, it sort of shows the alternatives where prisoners can choose their method of execution, and the lightest orange states show specific alternatives for both Missouri and New Hampshire only. Okay, so I want to talk about specific methods of execution. And I want to start with the electric chair, because for the longest time the use of the electric chair was the primary use for execution once we sort of moved away from hanging because it was deemed risky and inhumane. The first electric chair was developed during the War of Currents after engineers watched a drunk man die relatively quickly after he touched an exposed current wire. The chief engineer for Thomas Edison actually developed the electric chair using the AC currents that were developed by George Westinghouse. If you know anything about the currents, there's two types, AC and DC currents, and Thomas Edison was a proponent of the DC current. The AC current was much more dangerous, and it was known to explode and cause fires because it was hard to harness at first. Edison's engineers were trying to show that the DC current was safer to use than the AC current as a way to show how dangerous and deadly the alternative was. So in 1881, the state of New York established a committee to determine a new and more humane method of execution to replace hanging. And a member of the committee named Alfred Southwick developed the idea of running electrical current through a condemned man after hearing that case about the drunk man that I mentioned earlier. Southwick was a dentist, and he was accustomed to performing dental procedures in chairs. And he knew that if he could hook up the electrical device and hook it up to the chair, it was going to be able to restrain the inmate while that person was being electrocuted. So to prove the danger of AC electricity and to show that it was suitable for executions, Brown and Edison actually publicly killed animals with AC current for the hopes in sort of gaining press that would show how bad the AC current was and show how good Edison's DC current was. So it was at these events that the term electrocution was coined. The term electrocution is really referring to an electrical execution. And it's not accidental, and it's pertaining to non-accidental electrical deaths. However, since no English word was available at the time, the word electrocution eventually took over as a description for all circumstances that are surrounding electrical death as electricity sort of continued to develop. The demonstrations of electrocution apparently did what they were supposed to, and their intended effects were positive, and the committee adopted the AC electric chair in 1889. And on August 6, 1890, a year later, William Clemmer became the very first person to ever be sent to the electric chair. The problem is that nobody had done this before, and people were not sure exactly how much voltage needed to be sent through a man, so they strapped down Mr. Clemmer, and after he was strapped in, a charge of approximately 700 volts was delivered, and they delivered it for about 17 seconds, but the current failed. So the current failed, and Mr. Clemmer is still alive. Witnesses report smelling burnt clothing and charred flesh, and he wasn't dead, so they had to hurry up and get the generator running so a second shock could be prepared. The second shock was higher, and the second charge was about 1,030 volts, and it was applied for 2 minutes, and witnesses sort of saw smoke that was coming from Clemmer's head, but it was very clear that he was deceased. So they pull him from the chair, he's dead, and they go to perform an autopsy, and the autopsy reveals that the electrodes that were attached to Mr. Clemmer completely burnt through his body. From the autopsy report, the electrodes that were attached to the back of his neck and to his actual back had burned through his back so badly that you could see his spinal cord just by looking into his back. So obviously it didn't go well, and we're now making our way through electrocution after we use it for however many decades, and we're now beginning to use lethal injection, and it's becoming the standard in this country. Through the use of lethal injection, you have two options. You have either a 3-drug or a 1-drug cocktail that's going to kill the inmate. And I'm going to explain the 3-drug cocktail next, but the 1-drug cocktail is pentobarbital, which is not to be confused with phenobarbital, which is used to be treating seizures. Pentobarbital is a sedative, and when it's used in very high doses, it causes respiratory arrest and death. However, the Danish manufacturer that creates this drug is forbidding the drug to be used in any executions in the United States, and it's making it very difficult for prisons to get access to the drug here in the US. The 3-drug cocktail works like this. A medical doctor will be present for the execution. Some will be willing to insert the IV line for the executioners. Others will not be willing, but basically the doctor is there to call time of death. In this case, prison staff have to be trained to insert IV lines themselves, and this is often where the trouble starts in terms of botched executions, but we're going to talk about that in part 2. So the IV line is inserted and a saline drip begins. Once the saline has flushed out the IV line, then the first drug will be pushed through, and that's sodium thiopental, which is an anesthetic. Usually, the inmate will receive more than is recommended as a way to ensure that the inmate does not wake up during execution. Once the inmate has received the first drug, the line is going to once again be flushed out with saline, and then the muscle relaxant is going to be pushed through. This will essentially stop the inmate's ability to breathe as it paralyzes the diaphragm and the lungs. Then one more round of saline is pushed through the line before the final drug, potassium chloride, is administered to the inmate. Potassium chloride will stop the inmate's heart and will cause death. The doctor, like I said, will then call time of death, as that's their role in the execution chamber. The saline, though, is important. If you don't flush the line in between rounds of the drug, then the drugs will not work the way they're supposed to work. The drugs will interact and it will cause the inmate more pain and will prolong the death unnecessarily. But here's the thing, you actually don't need the potassium chloride to execute someone. The first 2 drugs will do the job, but the use of potassium chloride puts the inmate into cardiac arrest, and that makes things go faster, which is often why it's used. Inmates were concerned about whether or not you could really feel pain or if you would really be aware of what's going on once the sedative was administered. And once you're sedated, then basically you're paralyzed and you can't move, you can't talk, you can't say anything. So if you were somewhat conscious of your surroundings, how would this not be cruel and unusual punishment to be in this state and be conscious during your execution? So they take the case to SCOTUS, and SCOTUS rules that given the very high doses of each drug, you should not be able to feel anything whatsoever and not be in any way conscious of your surroundings. If the drugs are administered the correct way, then it is not considered cruel and unusual punishment. So the 3-drug cocktail is ruled constitutional and it's allowed to be used. The newest argument that was taken to SCOTUS very recently does not involve the 3-drug cocktail, but rather the 1-drug cocktail. And remember that there are drug shortages from the pharmaceutical manufacturers, and states are just getting and using what they can. Oklahoma used potassium chloride, the one that stops your heart, but we now know that something went horribly wrong during that execution in 2004. SCOTUS came back and said that you can use the 1-drug cocktail and maintain that it was constitutional as well, and that the botched execution in Oklahoma was a fluke, and it was a terrible one, but it was just a fluke. However, because there have been these issues surrounding the drugs, like I said earlier, the pharmaceutical companies have been reluctant to sell the drugs to different states, and it's creating a shortage. In addition, the American Pharmacists Association has urged its members not to sell the drugs, and pharmacists don't have to. If you get a prescription for the lethal injection cocktail, I as a pharmacist do not have to fill that prescription. So by sort of creating the shortage from the manufacturer and from the pharmacist not willing to fill the prescriptions, what it's basically doing is causing the state to have to set up alternatives like Oklahoma's recent approval of the gas chamber if they want to continue to execute their inmates. So this slide is very interesting, and you can see that it's changing, and basically what it's doing is it's showing you the progression of the use of different methods of execution in the United States. As you can see, for the longest time we used hanging as our primary execution method, and then we're slowly moving towards the electric chair. And then we switched once again and moved towards lethal injection. You'll also see when the moratorium on the death penalty post-Furman occurs and when it's reinstituted post-CRIJ. And you'll see how only certain states have decided to reinstate it. And now it just is going to repeat. Okay, so this is the last slide that I have for you in terms of figures that are surrounding the use of the death penalty. As you can see from this map, currently we have 19 states that have abolished the death penalty, plus Washington, D.C. None of them use it. Of the others, Texas, Oklahoma, and Virginia are leading the pack in terms of the number of individuals who have actually been executed. Of those three, Texas is of course outranking everyone in terms of the number of inmates that they have executed. This map is a little bit older and it only reflects executions up through 2013. At the time of this recording, Texas has increased from the 2013 figure of 496, and they've increased all the way up to 537 executions since 1976 and 755 executions if you consider all executions that have ever occurred, including those pre-1976. There are currently 263 inmates on death row. 6 of them are women. Additionally, there have been 13 death row exonerations in Texas, and those are in addition to the regular exonerations that have occurred without capital murder ties. The closest state to Texas is Virginia, and Texas still has about 5 times the amount of executions than Virginia does. So wrapping up, in this first part of the 2-part lecture series, we focused more on the legal aspects surrounding the use of the death penalty and the safeguards that have been put in place by SCOTUS. We also looked at the methods used in carrying out executions, whether at the state or federal level. As we evolve as a society and we blossom through technological advances, so too should our punishment methodologies. We can see that happening through the progression of techniques used to complete executions in the United States, and even though this country has executed 1,437 individuals since the reinstatement of the death penalty, things have not always gone as smoothly as practitioners have hoped. We know that we have executed innocent people. We know that we have messed up executions and that they have been botched. We know that we have wrongfully convicted innocent people and they are currently sitting on death row waiting for their exonerations. We know these things, but this country continues the use of the death penalty nonetheless. In the next and final lecture of the semester, we're going to be focusing on a variety of issues that we just mentioned and how they're causing problems for the justice system. Meet me back here one more time for our final focus on part 2 of the death penalty lecture.